My Lords, I rise to speak to the Amendment 45 tabled by my noble friend Baroness Sugg, and also to strongly and emphatically support the amendment moved by my noble friend Lord Farmer. I am unconvinced as to whether at the present time this Amendment 45 does actually ameliorate the concerns about the incompatibility with the European Convention on Human Rights, and I'll be interested to hear the Minister's specific answer to Baroness Sugg's question. I do believe, however, that this amendment is still disproportionate and is a significant attack upon freedom of speech and thought. Firstly, the amendment seeks to criminalise those who are, quote, influencing any person's decision to access, provide or facilitate the provision of abortion services. When compared with Clause 9, this is still extraordinarily broad and could potentially cover a whole range of innocuous activities. Now, I know there's a value judgment to be made between handing a leaflet to a vulnerable woman, offering financial support or housing support, but what about silent prayer, as we've seen examples more recently? And this amendment does not actually exclude the outside of private property. So anyone who is in their private garden or in their own car expressing their conscience could be criminalised. My Lords, for a law which specifically proposes to limit fundamental freedoms of speech, expression and even thought, should we not be very specific about which behaviours are being disapproved of and where? And yet this amendment is indiscriminately applied to every clinic in the nation. And as noted, the behaviours prohibited are far too broad. Indeed, in Clause 9, the 150-metre arbitrary curtilage limit actually referred to the abortion clinic at Mattock Lane, Ealing in West London as an arbitrary figure, for an example. Those behaviours, such as standing silently if admitting to praying, or found to have influenced by standing silently, are included, and quite how that applies is moot. Police and the Crown Prosecution Service will be left altogether unclear under 45 about when to bring charges or to prosecute anyone who contravenes this proposed law. This will likely lead to the disproportionate allocation of resources to this issue, simply because it is so broad and vague. And I think, as we've seen in recent cases in Birmingham and Bournemouth of Isabel Vaughan Spruce and Adam Smith Connor, who were arrested for silent prayer within the areas of two different PSPO buffer zones, that took people significantly by surprise, as they were not aware that in this country silent prayer had become criminalised. And I voted in the other place for the legislation in 2014, but it was never intended for such draconian use. These cases further highlight the dangers to free expression and belief that is inherent in these buffer zones. They demonstrate how we can quickly end up in the position whereby the specific act that could turn someone into a criminal is whether they had the particular thoughts in their head whilst in a buffer zone area. And I reiterate the comments of the noble Lord Weir. The mark of a free society is one that accepts the opinions which are unfashionable, which are held by a small number of people, and which one vehemently disagrees with, not those that one will necessarily agree with. I move quickly, as time is pressing, to the very sensible, balanced and reasonable amendment moved by my noble friend Lord Farmer. Given the serious limitations on freedoms that Clause 9 and Amendment 45 would impose nationwide, it is prudent to conduct a review as to whether there is a significant issue based on the evidence, and if so, what specific measures are needed to solve the issue. Indeed, the reason Parliament declined to legislate on this matter in 2018 was specifically due to a lack of evidence that a law was indeed needed. And furthermore, it was found that the vast majority of clinics did not experience demonstrations. Indeed, in the age of iPhones and social media, it seems to me if the sort of harassment being claimed from the other side of this debate was so prevalent, then we would see much more of it on social media and wider media networks. But this is not the case, and the government reiterated yet again last autumn that that was their settled view. And since the review in 2018, that they continue to keep the matter of abortion-related protests outside clinics under review. And very quickly, there are a huge portfolio of laws, specific bespoke legislation to deal with harassment and coercion and threats. The Local Government Act 1972, Public Order Act 1986, Criminal Justice Act 1988, etc. It would be entirely illogical to, having declined to make disproportionate law in 2018, based on a lack of evidence, to make such a law now, as enunciated by Baroness Sugg in her support for Amendment 45, with a similar lack of evidence that it is needed. Finally, what are the proponents of this Amendment 45 afraid of? Our laws should be based not on anecdote, like the Dangerous Dogs Act 1991, but on proper, robust, empirical evidence. My Lords, I hope tonight, in any event, we can test the will of the House on that issue.